As a real estate agent, you're obliged to comply with several statutory and regulatory requirements. These can be broken up in relation to the 6 key steps of the sale and purchase of a residential property. Step 1. Engaging a vendor. You are required under the Real Estate Agents Act Code of Conduct 2008 to prepare an agency agreement and have it signed by the vendor. The agency agreement should outline the agent's commission, how the property should be sold, marketing expenses, type of agency, timeframes, and the expiry of the agreement, and the sales price. Once the agency agreement has been signed, it is the agent's responsibility to deliver a copy to the vendor. For sole agency, the signed agency agreement has to be delivered to the vendor. They have until 5 p.m. on the next working day to cancel the contract as per Section 130. If the agreement extends past 90 days, as per Section 131, the vendor may cancel at any time, upon which the agreement becomes a general agency agreement. Step 2. Taking the vendors to the market. Unless authorised by a client through a signed agency agreement, an agent is strictly forbidden to offer that property on the market, which includes distributing any marketing material such as flyers or signage on the property. It is the agent's responsibility under the Real Estate Institute of New Zealand to obtain all relevant information about the property and check its accuracy, i.e. title, ownership and legal description. In addition to this, they must ensure any claims to the title are expressed in the title document, such as covenants, caveats and easements. When taking the vendor's property to the market, as stated in the Code of Conduct Guidelines under Section 9.1, a licensee must act in the best interest of a client and in accordance with their instructions. Step 3. Receiving offers. Just prior to this stage, the agent must disclose if they will receive any benefit from the sale. Following this, the agent must disclose any sensitive information and all known defects to the potential purchaser. An example of a case in which these obligations were not met was in the case of Rankin and Complaint Assessment Committee. In this case, Mr. Rankin, the agent, did not disclose to the potential purchaser that the property has been tested positive for methamphetamine contamination, which was a breach of statutory requirements under Rule 6.4 and 10.7. During the process of receiving offers from potential purchasers, under the Code of Conduct Guidelines, the agent must submit all offers to the client, provided they are in writing. If the licensee is employed by an agent, the licensee must provide all written offers to the agent and must retain a copy of these for 12 months. Step 4. Sale and purchase agreements. At this stage, the agent must provide a copy of the approved guide and communicate regularly with the client to keep them well informed of matters relevant to their interest. In the case of Ronald Harchak, a complaint was made against him under the pretext of unsatisfactory conduct, Section 89(2)(b). Ronald had countersigned an SPA on behalf of the vendor when he was not authorised to do so. This created a misrepresentation to the state of negotiations and matter of fact. He was penalised under Rules 5.1, 6.2, 6.3 and 6.4. This case is a good example of how not only must you follow your client's instructions, but you also must clearly communicate these to the purchaser, as outlined in 9.1 of the Code of Conduct. Step 5. Payment of the deposit. It is a statutory requirement that the agent must not pay that money to any person during the stakeholder period. This is 10 working days after the date on which he or she received the deposit. Over this period, the agent must act as a stakeholder. It is not recommended that the purchaser pay the deposit directly to the vendor, as they will become an unprotected creditor. Under Section 122, in the case of a failed condition, which results in the deposit being refundable, the agent must not take out their commission and must repay it to the purchaser. The agent can only deduct their commission once both the stakeholder and statutory periods have passed. Step 6. Settlement. Under Clause 3.2, the purchaser is entitled to a final inspection 1 to 3 days prior to settlement. The agent will need to be aware of this, and it is usually their duty to give access to the purchaser. Lastly, on the day of settlement, the purchaser will gain control and ownership of the property. The agent here will need to ensure they hand over any forms of access they have to the property, including keys and swipe tags.